That's you, 1, 2, 3, start.
In the land where liberty is promised by the Constitution, one man spent 14 years in the shadow of forgotten walls. Not as a criminal, but as an innocent man unjustly caged. He walked into prison as an accused and stayed behind bars for 14 years after being declared innocent. No trial, no conviction, just silence. This is not just the story of Ajay Das. It is a story of silence in power, justice delayed and dignity denied. What happens when the courtroom, when the Constitution forgets the value of a human life? The courtroom now becomes the last refuge, not just for justice, but for meaning.
Order in the court. All rise, please. Court is now in session. Please be seated.
Call the matter.
Criminal writ petition number 128 of 2025, Ajay Das versus State of Bihar.
Appearances.
May it please the court, I, Advocate Abhinav Thakur, for the petitioner Mr. Ajay Das.
I, Advocate Maitri Sinha, appear on behalf of the State of Bihar. Mr. Thakur, you may proceed.
Much obliged, Your Lordship. The petitioner Mr. Ajay Das was acquitted by the Sessions Court of Vaishali on January 20th, 2011. Yet he remained confined in prison until October 16th, 2025, a shocking period of over 14 grueling years. This is a blatant violation of Article 21, the right to life and personal liberty. We pray for immediate compensation and accountability.
Mr. Thakur, is the petitioner present?
Yes, Your Lordship. With the court's permission, may I request that Mr. Ajay Das be allowed to testify before this honorable court?
Permission granted.
Mr. Ajay Das, please take the witness zone. Please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may begin your testimony.
Your Lordship, I come here today not as a man seeking sympathy, but justice. In 2011, I was acquitted of all charges in a criminal case. The judge declared me innocent, but no one opened the gates to my freedom. Days turned into weeks, weeks into years, and I waited. The waiting wasn't painless either. I had to toil hard in the harsh conditions of a prison. I waited for someone to say, "You can go now," but they never did. I spent 14 years not serving a sentence, but waiting for the freedom that was already mine. They called me a prisoner, the disposed element of a civilized society, the lowest a man can ever be. But in truth, I was a forgotten file, a man erased by the system. They took everything from me, my family, my identity, and nearly my sanity. And so today, I stand here not just for myself, but for every citizen who believes that freedom is a right, not a clerical privilege.
Your Lordship, with your permission, I would like to examine the petitioner.
Permission granted. You may proceed.
First of all, after your acquittal in 2011, were you ever formally informed by jail authorities that you had been found not guilty?
No, sir. No one told me anything. I only knew because one of the guards let it slip in the passing. The court says you are free, but the paperwork's missing.
So, after your acquittal by a court of law, no warden, no jail official, no superintendent, not even a clerk ever handed you a release order.
So, no official communication reached you?
None, Your Lordship. No release warrant, no explanation, just silence.
Did you ever demand to see the jail records or request legal assistance?
I wrote many times. I begged to meet the jail superintendent. I asked the wardens. Every time I was told, your file hasn't come in, as if I was justified. They treated me like garbage. I was a freed man, trapped in the maze of the wretched system.
How can you such a misery?
Please maintain silence in the courtroom and continue with the proceedings.
You say you were held for 14 years post-acquittal. So, were you ever re-arrested, recharged, or presented before any magistrate during that time?
No, Your Lordship. I was never produced in court again. It was a time of utter confusion and silence. No one told me why I was still there. I had no charges, no cases, no crime left to answer for. I was an innocent man who had already paid his dues. Yet the world refused to let me go.
Did you ever try to reach your family?
There was no one left. My mother passed away while I was in prison. I found out 2 years after she died. I had no siblings, although I had some friends. The attempts to free me were futile, and I was abandoned so. I was left alone to rot in a corner of the nasty hell.
Please use appropriate language from the next time.
And the jail kept no record of your mental state.
They said I was unstable. They moved me to a mental ward in 2021. But I wasn't mad, my lord. I was just forgotten.
Mr. Das, have you ever been examined by a psychiatrist? Given any medication?
Yes, they gave me tablets, strong ones, but I don't know what they were. In addition, those poorly described medications also worsened my health.
Mr. Thakur, do you have any medical records to support this?
Yes, your lordship. There is an availability of a partial document from the mental health facility in Ranchi. In addition, there are other certain documents to support my client's claim. Your lordship, may I be permitted to submit them in evidence before the honorable court?
Permission granted.
Thank you, your honor.
Exhibit A, my lord, the acquittal order signed by the District Judge of Vaishali. Exhibit B, letters from the petitioner. And Exhibit C, medical records from Central Institution of Psychiatry, Ranchi.
Acquitted, yet confined for 14 years.
Are these documents attested and admissible?
Yes, your lordship. Each page is certified under Section 76 of the Indian Evidence Act. We are also prepared to call the medical officer and the jail official as witnesses. Should your lordship require any further verification?
The court admits Exhibit A into C through the record. Let them be marked accordingly and appended to the petition file.
Duly marked and admitted, my lord.
Grateful, my lord. Mr. Das, did you think that you would ever be released?
I stopped looking for the light of hope. I stopped believing in time. Waking, watering the dried up gardens, sweeping moldy floors, eating the same water down as twice a day. It was a nightmare. The wind and even after opening my eyes, I was stuck in the darkest episode of my existence.
Mr. Das, if this court were to ask you what was taken from you, what would you say?
My youth, my family, my dignity, but more than anything, your lordship, I lost faith, and now I am here to reclaim it.
Your lordship, that concludes my examination in chief of the petitioner.
Very well. Miss Sinha, do you wish to cross-examine the witness?
No, Your Lordship. We reserve our right but do not intend to cross at this stage.
Very well. Mr. Das, the court has heard you.
Mr. Das, you are excused by the court. Kindly step down from the witness zone.
Miss Sinha, the court shall now hear your submission.
May it please Your Lordship. I rise not to diminish the petitioner's suffering, but to place before this honorable court a broader and more complex truth. The continued detention was clearly unjustified. However, I submit with due respect that the lapse in question was administrative in nature, not deliberate, not malicious. It arose from a breakdown in communication between judicial and prison authorities at the time. Your Lordship, the officers involved operated within a fragmented system, and while their inaction had grave consequences, it was not born of intent to violate the petitioner's rights. We acknowledge that the petitioner suffered. The state regrets the prolonged detention, but I humbly submit that constitutional compensation under Article 32 is an extraordinary remedy reserved for clear, direct violations attributable to the state in its sovereign capacity. In this case, while there was undeniable delay and negligence,
it is respectfully submitted that the state cannot be held solely and financially liable for what was in substance an institutional failure. We leave it to the wisdom and discretion of this honorable court to determine what remedy, if any, is appropriate in the circumstances.
14 years, Miss Sinha. Should the court overlook that a man was deprived of his liberty for over 14 years? Not in secret, not by mistake, but in plain view of a functioning system. Does the state offer no explanation for why no effort was made, not even once, to confirm the legality of Mr. Das's detention?
Your Lordship, the state doesn't seek to excuse the lapse. We only submit that it arose from administrative inefficiency, not willful disregard.
Inefficiency is not a defense when liberty is at stake, Miss Sinha. Bureaucracy cannot be a shield for injustice. If liberty is the first promise of our constitution, then surely its denial must carry consequence.
After all, you cannot call it a clerical error when someone's freedom is treated like a lost umbrella in a government office.
Your Lordship, we do not mean to diminish the severity, but we do believe it is relevant to distinguish between willful abuse of power and failure in process. The latter, while unacceptable, should not invite the same degree of constitutional liability.
Your Lordship, if I may,
Yes, Mr. Thakur.
I must respectfully object to that line of submission. Whether the abuse was willful or a result of institutional inertia makes no difference to the petitioner, who spent 14 years in illegal confinement, wondering if freedom was out of stock for that season. To suggest that the Constitution distinguishes between types of liberty violation is with respect untenable. A violation of Article 21 is absolute, and any failure by the state to protect it, whether active or passive, invites constitutional consequences.
Objection, my lord. We do not deny the hardship caused, but it is to kindly notify my learned friend who might be distressed by uncertainty that public law remedies must be weighed with care. The state must administer justice without setting a precedent that punishes even those errors born not of intent but of confusion. Your Lordship, if confusion becomes a criminal offence, then we will have to start issuing arrest warrants to half the government departments and possibly their printers. Am I mistaken?
With due respect, confusion is not a defense when liberty is extinguished. Your Lordship, I suppose my honorable friend has failed to recollect the double-digit number of the deadly years that my client had to withstand in jail for. 14 years, my lord. In a democracy governed by the rule of law, silence and delay must not be rewarded with leniency. They must be corrected with accountability. My lord, if confusion is not a crime, your lordship, then perhaps we owe apologies to every criminal who simply misunderstood the law.
All right, counsel. And while you are trying to turn the courtroom into a stand-up show, some of us are still trying to argue law. No audition for applause.
Order, order, order. Maintain the decorum of the courtroom.
Enough. Both counsels have been heard. Mr. Thakur, you will have full opportunity to make your submissions following this.
Grateful, your lordship.
Ms. Sinha, do you have anything further?
No, your lordship. The state rests its submission.
Mr. Thakur, any witnesses to produce?
Yes, your lordship. With the permission of the honorable court, may I call Mr. Arvind Rao, the jail superintendent at Vaishali jail, to the witness zone.
Permission granted.
Mr. Arvind Rao, kindly take the witness zone. Please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do. Thank you, Mr. Rao. Could you please state your official positions and duties at Vaishali jail during the period of 2011 to 2025?
I served as the jail superintendent at Vaishali jail from 2011 until 2025. My duties include overseeing jail administrations, prisoners' records, and ensuring lawful custodies.
Mr. Rao, are you aware of a prisoner named Ajay Das held in your custody during that period?
Yes, Mr. Das was in my custody for several years.
Could you confirm if the official acquittal order dated 20th January 2011 for Mr. Das was ever communicated to you or acted upon by your administration?
Objection, my lord. My colleague here is trying to trick the witness based on his work, which he did many years ago. It is quite possible that he may not remember subtle details of that case.
Mr. Rao, do you have any proof to confirm any paperwork reaching your office?
Earlier today, I checked the pending files for the month of January 2011. No paperwork regarding Mr. Das' case sent by minister was found by me. I have also presented that file to the register.
Mr. Rao, with due respect, such failure borders on gross negligence. Is it credible that a system built on procedure, a document as vital as an acquittal order, is simply lost or ignored?
So now, liberty depends upon the memory of a clerk.
Your Lordship, I can only attest to the records I received. If the order was misplaced, it was beyond my control.
With due respect, your lordship, the burden of a misplaced order cannot fall upon an innocent citizen. If records go missing or orders are misplaced, it reflects a systematic negligence, not an isolated error. The guilt-free are trapped in the reckless consequences of the inefficient functioning of our government. This cost them their dignity, liberty and faith. Justice is getting misplaced as a file. My lord, how does it seek any justification?
Objection, my lord. The petitioner's counsel is turning an administrative lapse into sweeping indictment of the entire state machinery. This was a clerical error, unfortunate yes. But to brand it as systematic negligence is an exaggeration that undermines the scale and complexity of public administration. We object to this emotionally charged narrative being passed off as legal reasoning. There is no evidence of intent, no pattern of abuse, only an isolated delay. The state cannot be villainized every time a file is misplaced.
Objection, your lordship. Isolated delay. Does justice age like fine wine? The longer it is shelved, the more palatable its failure becomes. When such isolated error rob a citizen of liberty, they are no longer clerical. They are constitutional failures. The state may call it a lapse, but for the petitioner, it meant unlawful imprisonment. If the system can't safeguard freedom, then what exactly is it administering?
Order, order, order. Adjust to the pitch of the courtroom.
Pardon, my lord.
Miss Counsel for the state, emotional or not, the petitioner's liberty was at stake. Do not justify negligence with volume. Kindly take your seat. Mr. Thakur, you may proceed.
Your lordship, there are records or logs from the jail during those years that could verify Mr. Das's continued detention despite the acquittal. The testimony speaks not just of administrative failure but constitutional violation of the gravest kind. May I ask for the permission to present it before the honorable court?
Permission granted.
Thank you, your honor.
Exhibit D, the jail superintendent's report.
Mr. Rao, this is not just a lapse, it is a violation of liberty itself. Can you explain what systemic failures allowed this travesty to occur under your supervision?
Your Lordship, the system was flawed, communication gaps, bureaucratic inertia. I acknowledge the failure, but I was bound by the information I had.
Your lordship, let the record reflect. The prolonged detention of Mr. Das was based on undocumented assumptions, unverified reports, and a complete absence of a legal mandate.
Objection, my lord. The witness didn't act in personal malice. The system functioned on what information it had. In an overcrowded jail with dozens of pending files, records from a prior decade could easily get
Miss
lost.
Sinha, this is not an argument of volume. This is a matter of vigilance. One cannot misplace liberty on paperwork.
Your lordship, if I may add, it is precisely this casual bureaucratic convenience that deepens the constitutional wound. The state cannot speak of confusion when the cost of that confusion is 14 years of a man's life. Liberty is not a file to be lost in a tray.
With respect, your lordship, the learned counsel is turning an institutional error into constitutional violation. The superintendent acted within the bounds of routine procedure. There was no malicious intent, only miscommunication.
Malintent is not the standard, your lordship. Our constitution imposes a positive duty, not merely to avoid harming citizens, but to affirmatively protect their rights. To reduce such a fundamental failure to routine is to normalize injustice.
And yet, your lordship, the relief being sought is extraordinary. Constitutional compensation under Article 32 must not be granted in every instance of administrative error. Else, the line between public and private law dissolves.
This is not every instance, your lordship. This is an unbroken constitutional failure multiplied across 5,000 days. If this does not call for extraordinary remedy, what possibly could?
Objection, my lord.
Objection overruled. Enough. Both counsels have been heard. Mr. Rao, you may step down.
Mr. Rao, you're excused by the court. Kindly step down from the witness zone.
Your lordship, with the permission of the honorable court, may I call my next witness, Dr. Nilima Sen?
Permission granted.
Dr. Nilima Sen, please take the witness zone. Please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth? I do.
Thank you, Mrs. Sen. Dr. Sen, you served as the medical officer at the Central Institution of Psychiatry, Ranchi from 2014 to 2025. Am I correct?
Yes.
Was Mr. Ajay Das under your care during that time?
He was admitted in 2019 and discharged in 2025. I was his overseeing officer throughout.
Dr. Sen, was Mr. Das ever diagnosed by a certified psychiatrist with a condition requiring long-term institutionalization?
No, he exhibited signs of withdrawal and trauma, but no formal diagnosis of mental illness was ever made.
Was he kept in the hospital under a court order or under medical necessity?
Neither. We were told he had no known address, no relatives, and no diary for release, so we held him.
Dr. Sen, you're telling me you just held a free and sane citizen against his will among psychiatric patients just because you had failed to get any information about his whereabouts. Withdrawal and trauma are now just enough to justify indefinite confinement. Interestingly, by that logic, we should institutionalize half of the country. Didn't you have any provisions to let a self-sufficient man be on his own?
We have...
Objection, my lord.
We will get to you, Miss Sinha. Let us continue with the proceeding.
Do you understand what that amounts to?
Yes, I do now.
Your lordship, the state's defense is that this was a merely bureaucratic lapse, that it lacked malice, that it was merely a forgotten file. But this witness has just testified that Mr. Das was held in medical custody without a court order, without medical grounds, and without legal review for 5 years.
Your lordship, I object to the mischaracterization of institutional procedure.
Then clarify it, Miss Sinha. Tell the court what procedure permits detention without diagnosis.
Order, order, order.
Counsels, this is a court of law, not a theatre. Maintain order.
Your lordship, I apologize, but I must press. If no law permitted it and no doctor prescribed it, then what exactly kept Mr. Das confined? Doctor?
No law, no doctor, just silence. He became invisible and we were told not to question the paperwork.
What do you mean a walking, talking man became invisible? Do you realize how disastrous your keeping quiet was? Tell me, how was that? Verbal instruction or written?
Verbal, passed down from the jail authorities.
No memo, no records, only whispers and habits. I wonder why the jail authorities would even interfere with the working of a psychiatric institution. This is just slanderous. Your lordship, this is not medicine. This is incarceration masquerading as care.
Objection, my lord. The doctor wasn't acting maliciously. She was operating in good faith. Under institutional pressure, these remarks verge on slander.
Your lordship, I am not questioning Dr. Sen's intentions. I am questioning a system where good faith becomes the burial ground for accountability.
And I submit that my learned friend is politicizing an administrative oversight. Is the state now to be held criminally liable for clerical errors? My lord, in my petitioner's version of events, good faith is a crime and every delay is a personal act of evil. Perhaps some moments later, the stenographers would be summoned next since they have plotted the entire justice by one keystroke.
This is not an error. This is 14 years of a man's life. If that is clerical, then let this court define what liberty even means.
Mr. Thakur and Miss Sinha, you both are very dangerously close to contempt. This court will not tolerate any type of shouting or disrespect. Doctor, did Mr. Das ever ask you to leave?
Yes, many times. He wrote a letter in 2023, a simple one-line plea. Is there a reason I'm still here?
And what did you do with it?
Filed it, unsent.
That, your lordship, is the voice of every man buried under the dust of our institutions.
Miss Sinha, would you like to cross-examine?
Yes, Your Honor. Thank you. Dr. Sen, you have stated that Mr. Ajay Das remained institutionalized without any formal medical diagnosis. Yet, he was emotionally withdrawn, frequently silent and aggressive at times, correct?
Withdrawn, yes, but never aggressive, never dangerous.
And was it not prudent, given his history, that he be kept under observation?
Observation, yes, but for 5 years, without re-evaluation, without medical grounds.
With respect, doctor, is it not also true that our facility was operating under immense constraints? No digital records, limited staff, and hundreds of unresolved case files.
Yes, but that...
So then you agree, this was not malice. It was overburdened, simply a human error.
Objection, my lord. This is not a question. It is a justification.
Sustained. Miss Sinha, you will frame your argument properly.
Apologies. Dr. Sen, did I personally order Mr. Das to be held?
No, I inherited the file, but I did not challenge it either.
And you believed, as did others, that Mr. Das had no known home, no family, no further trial, and therefore was best kept under medical care?
No, Miss Sinha, we believe nothing. We stopped asking. We filed him away, like paper, not a person.
Your lordship, may I speak now?
Proceed.
Your lordship, what we have just heard is not a defense. It is a confession, delivered beneath the weight of silence. Miss Sinha says this was not personal, that no one meant harm. But what is more terrifying than a state that causes such harm without even noticing?
Your Lordship, this is argument or theatre.
You want restraint, Miss Sinha. 14 years in wrongful confinement, and you expect me to whisper? Is that reluctance or fear dressed in formality? Does justice make you nervous?
Mr. Thakur, mind your tone.
Noted, your lordship, but I submit that this courtroom cannot afford politeness when the constitution has been trampled. Let me be plain. A man acquitted by law was held without sentence, diagnosis or review. This is not a clerical error, it is a constitutional betrayal.
Those are weighty words, counsel.
Pardon my lord, but this is a weighty wound, suppressing the value of human justice. They say the state was overburdened, but our jails are not godless machines. They are bound by Article 21, and the right to life does not expire just because a file goes missing.
Objection, my lord. No one here denies the seriousness of the situation. But the state cannot function under the weight of moral absolutism detached from operational reality. Yes, jails are not godless machines, but they are also not immune to collapse under bureaucratic burden. In the initial 21st century, my lord, in Bihar, infrastructure was fragile. The record-keeping manual and staff all were overwhelmed.
With respect, your lordship, if our systems cannot safeguard liberty, then the scale of their workload is no defense. It is the very cause for scrutiny.
But surely, counsel, even you must agree, one cannot criminalize every administrative lapse as a constitutional crime. Should we start framing charges every time a lawyer turns paperwork into poetry and delay into drama?
Your lordship, we are not here to vilify a doctor or a jailer. We are here to say When the state forgets its citizen, it owes more than apology. It owes accountability.
Your Lordship, the state acted in good faith.
Miss Sinha, good faith is not a license for constitutional injury. No one here is criminalizing error, but this is not an error anymore. This is prolonged illegal detention, and the moment it crossed into years, it stopped being accidental and became unconscionable.
Mr. Thakur, you can continue.
Your Lordship, I ask this honorable court not to award token compensation. I asked it to declare with clarity that the Constitution does not tolerate passive cruelty, that the loss of liberty is not an administrative inconvenience, that a man's stolen years are not footnotes in a file, and that if the state forgets, the court will remember. We rest our case.
Very well. Doctor said and stepped down.
The court will now consider judgment. But before that, Miss Sinha, you have heard the petitioner, you have heard the facts. The court now is prepared to rise, but before it does, if the state has anything of substance left to offer, then this would be the time.
But let me be abundantly clear. If you rise to repeat the well-worn script of overburdened files and systematic stress, then I advise against it. This court does not confuse procedural inertia with legal justification, nor does it confuse administrative silence with constitutional compliance. The liberty of a citizen once taken cannot be returned by excuses. It is only restored by truth, by accountability, and by the rule of law. So I ask you plainly, does the state wish to say anything else, or shall we just proceed to judgment?
No, Your Lordship, the state rests its case.
Very well.
The court has heard all the submissions. Now we will be pronouncing the judgment.
All rise. This honorable court will now pronounce the judgment.
Please be seated. This is the judgment of the Honorable Court in the matter of Ajay Das versus the State of Bihar. The facts of this case are not in dispute. A man, Ajay Das, was acquitted of all charges, yet was detained in a state institution for 14 years beyond his release date. The reasons for the prolonged detention lie in administrative neglect and systematic failure. Liberty is the most precious right guaranteed by our Constitution under Article 21, the right to life and personal liberty. No procedural lapse or bureaucratic burden can justify its deprivation. This court unequivocally holds that the continued detention of the petitioner amounted to a gross violation of constitutional rights. Such detention is illegal, arbitrary, and must never be repeated. The state is hereby directed to pay just and adequate compensation to the petitioner for the violation of his fundamental rights, the loss of liberty, and the years spent behind bars. Further, this court mandates that the state establish clear mechanisms for regular review of detainee status to prevent such miscarriages of justice in the future. Let this judgment stand as a solemn reminder. No citizen's liberty is expendable under administrative oversight. The petition is accordingly allowed. The court now is adjourned.
This honorable court stands adjourned. All are requested to maintain decorum while exiting.
And at last, the silence was broken, not by apology, but by justice. The court did not just free a man, it awakened the nation. For the first time, the law reached beyond the cold procedure and touched the wounds of liberty. But can a certain amount of money ever buy back 14 stolen years? The verdict was not the end, it was a beginning. A reminder, when the state forgets, the Constitution must remember.